I am Daniela Oliveros, and for the continuation, we have Part 4, Litter and so on. The EPA, or the Environmentalist Protection Agency, brought in new procedures regarding the control of litter. Section 87 created the offense of leaving litter, and Section 88 brought in fixed penalty notices for leaving litter. Section 99 also gave LAs the power to deal with abandoned shopping and luggage trolleys. In this part, the EPA has the aim to control and reduce the litter or trashes in order to preserve our environment, with the help of Section 87 that has the power or duties to manage the litters that is associated with environmental issues. Under this, both duty bodies and citizens are given rights to take legal action to get areas cleaned up. In Section 89, it provides fixed penalty, or there is a fixed amount that you need to compensate once you fail to comply the section. This offense can be prosecuted through courts if you fail to pay and give informations. Part 5. Part 5 of the Act makes a number of amendments to the Radioactive Substances Act 1960. The principal amendments being provision for the appointment of inspectors, provision for a scheme of fees and charges payable for registration and authorization under the RSA, new powers of enforcement, that is enforcement notices, withdrawal of exemption in favor of the UK Atomic Energy Authority from certain requirements of the RSA, and application of the RSA to the Crown. This Radioactive Substances Act also refers to Principal Act. It deals to dispose any radioactive waste. Radioactive hazard also exists whenever radioactive material are stored or discarded. This act protects the environment from radioactive pollution by controlling its usage. It must be registered and authorized. Part 6. Genetically modified organisms. This purpose of this part is to prevent or minimize any damage to the environment that may arise from the escape or release from human control of GMOs. The picture shown here is a statutory nuisance procedure under the Environmental Protection Act, which ensure and to investigate if there are nuisance complaints observed and if further actions or response is needed to deal with the problem. The following definitions are important here. First is we have the term organism means any acellular, unicellular, or multicellular entity other than humans or human embryos, and unless the context others requires. Biological matter meaning anything that consists of or includes tissue or cells, or subcellular entities of any kind capable of replication or of transferring genetic material. Second is genes or other genetic material in any form that are so capable. And lastly is we have the immaterial. It is to identify if something is not an organism or biological matter. An organism is genetically modified if any of the genes or other genetic materials in the organism have been modified by the means of an artificial technique prescribed in regulations by the Secretary of State. It is inherited or otherwise derived through any number of replications from genes or other genetic material from any source that were so modified. Second is the techniques that may be prescribed for the above purposes include modifying genes or other genetic material by the recombination, insertion, or deletion of any component parts of that material from its previously occurring state. Other technique for modifying genes or other genetic material that in the opinion of the Secretary of State would produce organisms which should for the purposes of this part to be treated as having been genetically modified, but do not include techniques that involve no more than the assistance of naturally occurring processes of reproduction, including selective breeding techniques or in vitro fertilization. Section 108 of the Act requires that no person shall import or acquire, release, or market any GMOs unless before so doing. Section 110 empowers the Secretary of State to serve a prohibition notice on any person there is reason to believe. A system of consents, however, is operated by the Secretary of State's office whereby a person importing or acquiring, releasing or marketing GMO may be subject to certain limitations and conditions. Part 7. Nature Conservation. This part established nature conservancy councils for England, Scotland, and Wales and their functions, both generally and specifically. It focused on protecting species from extinction, maintaining and restoring habitats, enhancing ecosystem services, and protecting biological diversity. Part 8. Miscellaneous. The most significant of the miscellaneous provisions of this part are power to restrict the importation, use, supply, or storage of substances or articles for the purpose of avoiding pollution or harm to human beings, animals, or plants. Power to restrict the importation or exportation of waste for the purpose of preventing pollution or harm to human health or for conserving facilities or resources for dealing with waste. Power to make provision for obtaining information about substances that have the potential to cause pollution or harm to human health. Provision of public registers of potentially contaminated land, amendments of the legislation of control of hazardous substances, and the rest are increased in the maximum penalties in respect of water pollution offenses, amendments to legislation as to marine deposits and the creation of public registers as to such deposit and marine incineration, amendments to the provision regarding oil pollution offenses from ships, provision for the control of stray dogs, and provision regarding to the burning of straw, stubble, and other crop residues. The Environment Act 1995. This act brought in a number of new arrangements for dealing with environmental pollution. In particular, the creation of the Environment Agency is for England and Wales. From April 1, 1996, the Environment Act brought together HM and Inspectorate of Pollution, the National Rivers Authority, and the local waste regulation authorities. The Act contains detailed provision for dealing with range of environmental problems and issues, namely, first is we have the air quality. It is an early legislation to establish a national strategy and framework of ambient air quality standards and targets for 9 main pollutants. New powers for local authorities to review air quality in their districts and create air quality management areas where levels fall short of targets. Contaminated land. The polluter pays principle was reinforced, but there was also recognition that landowners should be responsible for some aspects of the land. If the original polluters cannot be found, no new classes of liability were created. This approach requires remedial action only where there is significant harm or pollution of controlled waters and where there are appropriate and cost-effective means available to take such action. Pollution from abandoned mines. Statutory protection will be removed from the owners and operators of all mines abandoned after the end of 1999. This will allow the national agencies to deal with discharges through consents. As with other pollution discharges, failure to comply with these consents will lead to prosecution. Mine operators will be required to give the agency 6 months' notice of their intention to abandon a mine, thus allowing steps to be taken to prevent future mine water pollution. National Park Authorities. In England and Wales, local authority members will be drawn from parish rather than country councils and will be appointed by the Secretary of State. NPAs will be required to foster the economic and social well-being of their local communities, as well as protecting the natural beauty of the areas in their stewardship. Government and other public bodies must consider national park purposes in carrying out their functions. Waste strategy. Sustainable development will be the cornerstone of the strategy, that is, making the best possible use of unavoidable waste and minimizing the risk of pollution or harm to human health arising from waste disposal or recovery. Producer responsibility. Regulations would be introduced to impose producer responsibility to increase the reuse, recovery, or recycling of any product or material. The powers would be applicable to any waste stream. It is through regulations on packaging under these powers that the government intends to fulfill its obligation to implement the recovery target in the EC Directive on Packaging and Packaging Waste. Water conservation. Water companies would be required to promote the efficient use of water by their customers. The Director General of Water Services will monitor this work and publish conservation performance league tables. Water quality. The Environment Agency would have powers to require action to prevent water pollution and require polluters to clean up after pollution incidents. Combined heat and power. The Act amends the Electricity Act 1989 to enable CHP to compete effectively for support under the fossil fuel levy with other forms of non-fossil electricity generating schemes. And lastly is the Nuisance Provisions. The framework for the control of statutory nuisance contained in Part 3 of the Environmental Protection Act 1990 would be extended to Scotland. The Criminal Justice Act 1991. The Criminal Justice Act brought in provision relating to unit fines. A stated aim of the CJA is to encourage the use of fines to make their effect fair on offenders of different means, and to decrease the incidence of fine defaulters becoming imprisoned, which is written in Section 17 to 24. When the court is determining the seriousness of an offense, relevant factors that must be considered are aggravating and mitigating factors relating to the offense itself. Second is aggravating factors disclosed by previous convictions, such as similarities when considering a fine, the facts of all other associated offenses. The offender's means. The means of the offenders are reflected in a court's calculation of the offender's disposable weekly income. This is essentially 1/3 of what remains of an offender's income after the deduction of general living expenses. Thus, by establishing fines at a level that an offender can afford to pay, it is envisaged that few offenders will be involved in fine default courts, which reduces the risk of being sent to prison for so doing. Failure without reasonable excuse to provide this information can result in a fine not exceeding level 3 on the standard scale. On the other hand, a person who knowingly or recklessly makes a false statement or fails to disclose any material fact is punishable with up to 3 months imprisonment or a level 4 fine. Default arrangements. Section 22 deals with the maximum periods of imprisonment in the event of an offender defaulting on the payment of a fine. See Table 3.3 and 3.4. For those cases where a fine has not been set in units, Section 23 of the CJA states the maximum period of imprisonment in default for a given amount of fine. See Table 3.4. Exceptions. Unit fines do not apply in any cases where the offender is a company. Certain offenses may not be covered by the system as the offense is committed by a corporate body. In other cases, however, identifiable individuals such as directors may be responsible for the offense and subject to the unit fine provisions. The unit fine system does not apply to fines imposed by a Crown Court, even when cases are committed to a Crown Court for sentence. On the other hand, even in those instances where unit fines do not apply, Section 19 requires that a court, when deciding a figure for a fine, must take into account the means of the offender, and this may result in an increase or decrease in the fine imposed.